Good day everyone, I am Michael, the moderator for this webinar. I welcome everyone for today's webinar, which is Disciplining Students with Disabilities, What the Law Requires. It's a great pleasure for me to introduce our presenter for today, Hope and Kurz. Hope and Kurz, MAED, ESQ is a licensed special education teacher and 25 plus years litigation attorney. She has a bachelor's degree in special education from Boston University, cum laude, a master's degree in special education from New York University, 30 plus postgraduate credits in educational supervision and administration, and her law degree from Brooklyn Law School. She is a frequent speaker nationally and locally on education law. I would now like to hand over the floor to the speaker. Over to you, Hope.
Thank you. So first we've got some terminology. Suspension versus expulsion. Suspension is temporary. It's a specified period of time. And expulsion is permanent. Expelled students, long-term or expulsion hearing coming up. Now it's really important to understand the competing rights, why we have discipline. Okay, so in your state, what you want to do is you want to look at the Constitution, which your state Constitution probably provides for free public schools. So a word about private schools before we begin. There are no rights other than you are looking at the application or the enrollment form in the student handbook. Change in placement. We're going to discuss that, and the 10-day rule and multiple suspensions. Suspensions in the 10-day rule, that can be found in the Code of Federal Regulations 34 CFR Section 530B. After 10 days, it becomes a change of placement. But what constitutes a removal? When a student is facing more than 10 days, 10 consecutive or 10 non-consecutive of the substantially similar behavior, there must be a manifestation determination review, or an MDR. This is true for both a student with an IEP and a student with a 504. These are the determinations to be made at the MDR. So the MDR, who attends? So pointers for parents. No minimum notice is required for the MDR. So what do you think? Was this a manifestation or not? If you're going to do a functional behavior assessment, an FBA, what is it? It is actually not defined, and it is not required except when a student is removed from the educational environment or when there's a manifestation. Miscellaneous info when it comes to FBAs. So after the FBA, the IEP team develops a BIP. Okay, miscellaneous information. So there are special circumstances which are exceptions to MDRs. Okay, so if it is not a manifestation and not due to failure to implement the IEP, what happens? The student has a disciplinary due process hearing, and that would be for long-term suspension or expulsion. What happens at the disciplinary due process hearing? So the appeal of an MDR or a disciplinary placement is that the parent would file a due process complaint and ask for an expedited due process hearing. Everything is shortened, very abbreviated, and no extensions whatsoever. Some states have exceptions for young students. In Arizona, we have one for students in kindergarten, first, second, third, fourth grade. I tell that to you only because check your statutes. Sometimes there are exceptions. Disciplining students with 504s, it's similar protections to students with IEPs. So there are some students who have protections even if they don't have an IEP. What is the basis of knowledge? Basis of knowledge means that the school is deemed to have knowledge, to know that a child has a disability if, before the behavior that precipitated the disciplinary action occurred, before the behavior, not after, if the school is not deemed to have basis of knowledge of this. So conditions that apply if there's no basis of knowledge. Informal removal of students with disabilities, recent developments. So what are informal removals? So examples of informal removals include other informal removals or anything that is basically not documented. Threat assessments. And this is a way to balance FAPE and school safety. What is a threat assessment? So a threat assessment is a systematic process that's used by schools to evaluate the risk of violence posed by a student. So when is it conducted? There are transient threats and there are substantive threats. So this is these are guidelines from CSTAG on how to conduct a threat assessment. It's a CSTAG is an evidence-based model of school threat assessments, and this is the decision tree. You evaluate the threat. And so that's the end of this presentation. Okay, thank you. So I see people on both sides on this call, and we always try to work it out because no one wants a child to be suspended or expelled without services, whether they have an IEP, a 504, a general education, and that child just needs help. So just try to work together to find a solution. And thank you very much, and everyone have a great summer.
Thank you. Once again, thank you, Hope. So that does conclude the session for today. Thank you everyone for participating.
Thank you.
You may all disconnect now. Have a great day ahead. Bye-bye.